All right, good morning. Good morning. We are back for another GAR contract session. This time, one of my favorite sessions, the bonus forms you may not know. This is things that don't get used as much as they probably should be, and things that maybe you're not as aware of. So let me share my screen here. I'll do my favorite little pop out of myself in front of the screen. How's that? Everybody got me? All
That's
right.
good.
So let's get into it. Just as a reminder, we are not lawyers, so these are opinions and interpretations. If you actually need a legal opinion, talk to somebody that has a law degree. Um, all right. So first form up is the reminder of important dates in a purchase and sale agreement. This is one of my absolute favorite forms. I cannot tell you how many times in a transaction one side thinks one thing, the other side thinks another thing. People don't remember. Clients are like, wait, you didn't remind me that that was when that ended. I don't know, the lender, blah, blah, blah. So this is the form that you can use that will solve most of that. It doesn't solve it all, but it'll solve most of that. Um, so if you look at, obviously you're going to put the names of the buyers and the sellers, the date, the contract was written, the address that it's for, and then you'll fill out anything that applies down below, which is the next page. And that is, of course, binding agreement date, earnest money, when it's due, additional earnest money due, additional option money, the due diligence period ending, appraisal contingencies, finance contingencies, source of funds, deadline for documents to lender or attorney, which I don't think that usually gets in there, but okay, closing, possession, and anything else that you wanted to add that might be relevant. You send copies to, and you put all the people on there. You don't necessarily have to put um, addresses, but you can for all of those. It's not a bad idea to go ahead and put addresses and phone numbers for the lender and the closing attorney and the agents. That way, everybody has everything all on one page. And I think that's a really good form to distribute. Now, here's the question. If I fill this out and I say that due diligence was March the 25th, does that make, I mean, binding agreement date was March the 25th. Does that make binding agreement date March the 25th?
No.
No. This is just a record of what the contract says. There's a little paragraph that I thought I had copied on there, but it doesn't seem to be. Oh, no, no, it's in this one. The dates referenced below are not intended to alter or amend the purchase and sale agreement. In the event of a conflict, the agreement shall control, right? So whatever the contract says is what really is. So just because you fill this out, but here's the thought. If I fill this out at the beginning of, right after I go under contract and I send it to all these people, if anybody has confusion with it or anybody, or I did it wrong or whatever, hopefully they speak up, right? And they say something, because that would be the ideal outcome that comes out of that. And then you can modify it, fix it, and make sure everybody's on the same page. So just be aware, this doesn't change any of these dates, but it does put them all in one easy to read place so that everybody involved, including the people that you're sending copies to here, which of course you would want to copy your clients as well, so that everybody is aware of what this is. Any questions about this form? Pretty straightforward.
What would, I mean, if, let's say we were accepting the offer, will you still fill this out and send it to everybody? You don't have to be the one that's actually wrote the offer.
No, I mean either party could fill one of these out. I personally think that the buyer is typically more likely, the buy side is more likely to fill this out because more of these dates pertain to them. Um, but again, either side could fill it out. It doesn't matter. I think it's if the buy side's not going to fill it out and you're the seller side, I would probably do one if you don't get one. Or if you ask the agent, hey, do you do a reminder of important dates? And they're like, oh, I don't know what that is. Oh, okay, well, I'll do it. Right. And that way, at least it's someplace. I think it's a good idea. But that's a good question. Let's go to the next one. The estimate of the net to the seller. How many people have used this? Anybody? Show of hands? Sort of. Okay. All right. Not a big group. I personally think this is a great form to give to a client. I don't necessarily think it's a great form for us to fill out because oftentimes we don't know the answers to some of these things. The other thing is that if you have a client that let's play some generic descriptors. If you have a client that's a loving, caring, tree hugging, um, just that non-analytical type, let's call it that. Um, I wouldn't want to give this to them, right? Because they're going to look at this and they're going to go, "Oh my God, I have to do math? Like what? I don't want to do that. I can't answer that. That's not how I'm going to do this. I don't understand that." And it's going to confuse the shit out of them. But if you have somebody that's like super, like an attorney or an engineer or any other like OCD type personality, kind of like Seth, then you're going to want to give them this form so that they can do their work, do their due diligence to fill it out and do the things that they need to do. Obviously, the loan payoff stuff, I don't need to know any of that stuff, right? Like that's not stuff that I, as their agent, need to know. But if they see all of these blocks and they see, oh, okay, wait, here's the principal. Oh, penalty. No, I don't have either of those. All right, here's my accrued interest, blah, 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 days, number of days of the closing, yada, 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 all that kind of stuff. So they can do that. And then of course you can help them understand how it works if they have questions, but at least it gives them some idea to that. Um, the important things, some of the important things they get to pay attention to up here is projected closing dates and month the tax bill is paid, because that makes a difference. Um, Cost of the sell, any of the contribution to closings, the unpaid property tax, any of these other things, the brokerage fees, all that kind of stuff. And then of course credits, and then that gives them their estimate. But I would let them fill out this. This is not one that I would do for them. Any questions on this form?
Uh, if you send it to them, this is a newbie question. If you send that to them through app files, is it still fillable? I mean, they can, it'll still calculate or it won't.
So question, I don't know the answer to that. In Dotloop, you can send it with fill and sign. So they can definitely do that. I would imagine that app file does that as well, because I know Tina always says app files is the more powerful program. So let's call it yes. And we'll have to confirm that. From that standpoint. Uh, but yes, good question. Um, Estimate of cost of the buyer. How many people have used this? Nobody. Okay. So Ken, that doesn't surprise me. You do mostly listings, so I'm okay with that. But Robin, I mean, you do mostly buyers, like, and you just don't do these forms? Okay. So again, potentially something that you might want to have them fill out versus you fill out, but it's a helpful sheet to help them understand kind of the details of what things are involved in their cost, right? Like it's another way of not having a surprise at closing or not having a surprise when they see that first closing disclosure. I think so many of us fall back on the let's get a closing disclosure and that'll tell them everything they need to know. Um, Closings, I just did a closing, I don't do them very often, but I just did a closing and the attorney actually got us the closing disclosure for the seller side because I represented the seller like way early, like probably a week after contract or something like that, super early. Um, but it was a fairly simple one. There was no loan to pay off. There was, so I think that's part of the reason why it came so easy. So again, you can rely on the attorneys to do this. And yes, they are better at it than we are. But at the same time, if you need to give your client, and they're that personality type that this will help them, right? This will help them process. They're not going to, you don't want them to be surprised. You don't want them to fall into that. Wait, I have to pay taxes and escrow insurance. Like, I don't understand, like all of those sorts of things. Miscellaneous charges. It just lists out all of these potential things that they may not know what they are, right? Now, here's the flaw in this. If you provide this form to one of your clients and they say, hey, what's the Georgia intangibles tax? You need to be able to answer that question, right? So whether you need to Google it or ask a friend or whatever, how does the proration of property taxes work? What's the security deposit? Like just all these kinds of things. You need to make sure you understand what you're handing to them, which is the whole point of this entire contract series, is that you should understand what you're asking someone else to fill out or sign. So this is that total estimate of cost to the buyer. Again, I think it's a very valuable form, more valuable for them to understand kind of how it works. Like I love that it points out that the first year's premium of homeowners insurance is in here. Because most, a lot of times people are like, well, I pay every month or whatever. No, no, that's not how homeowners insurance works. It's not like car insurance. And so it's a very interesting form with a lot of good information on it. All right, let's get to some more commonly used forms, but still not in the mainstream, unfortunately. This is the last piece on here is the estimate of the monthly payment. Again, you probably don't want to be the one filling this out, but you could get the lender, this is going to spur the questions. Okay, what could other be? Are there other fees on my loan? Maybe. I mean, it depends on the lender, right? Like you got to pay attention to that. So I think those are good things to have. All right. Notice. How many people have used this notice form? All right, I got one solid, sort of. Okay. This is kind of like the generic amendment. It's the generic notice. It's the any time I need to give notice for anything, I can use this form. And I can, as the buyer or the seller, give notice to the other side. If we remember from the contract, when we went through the contract, there are specific requirements of the notice. The notice has to be signed by someone. And so here you'll see the signature of the party giving notice. There's two slots for it. I only showed one. You print or type their name, and then you can deliver it through these different methods of delivery. Let's remember, facsimile is one of the options, right? Facsimile. A fax is one of the options. Maybe one day they'll take that off. Somebody asked me yesterday or the other day, can I fax something? And I was like, I don't know. Yes. Oh, that was Ken. That's right. And I was like, yeah, I think so. But anyway, if the contract does not have a fax number on it for the other side or for your side, is using a facsimile a valid method of delivering notice?
No.
No, it is not. So you need to be careful about the method of delivery. Is in person valid delivery method? Every single
Yes.
time. So if you want to in-person deliver, which is usually only semi-convenient if you happen to be in the same office as the other party. But there's rarely that you're gonna, even that might be a challenge. You can do overnight delivery, you can do certified or registered mail, and then of course, assuming that they have an email address in the signature section, you can send it via email. The signature of the party giving notice. Does the signature need to be your signature or your client's signature? This is a good little million-dollar
Client.
question. It should be the client that's giving notice, right? Now, we are allowed to give notice on behalf of the client, but I think as a CYA, as an agent, it's not a bad thing to just have them sign it. In this day and age of electronic signatures and it being that easy, that's kind of a bonus, right? Because now they can't say, well, that's not what I meant. No, that is what you meant. You signed it, right? Like, and so that way there's no confusion. We are technically allowed to sign it as a representative of the party, but again, I like to have the client sign it because I think that it is more important to go the other. And you'll notice it says buyer or seller hereby gives notice, not buyer's agent or seller's agent. So again, I lean heavy on having the client sign it. All right, so this is our blank amendment, blank notice. We can use this notice for anything we want, right? Because there's this big blue box that I only showed a very small part of that you can write whatever you want in there. I hereby give notice that the property was infested by fleas over the weekend. It's something you could give notice on. If you want to make sure that there's no blowback of, well, you didn't tell me that you had fleas. Well, it is what it is. Now let's get into some specific notices, because just like all GAR contracts, there are some special use cases. This one is the notice to unilaterally extend closing date for 8 days. I don't have to ask. More than likely, most of you have used this one or had this one used in a transaction at least once. It does get used a lot. And what I love about it, it is very, very simple. It is, here's the information on the contract and the dates. Here is, it's either the buyers or the sellers giving notice, can be either. Doesn't have, there's not a correlation between these check boxes, these radio buttons here for buyers or sellers, or the options, and there's only two options. It's either the sellers cannot satisfy valid title objections, or the buyer's mortgage lender or closing attorney cannot fulfill their respective obligations. That's it. That's the only two reasons that I can do an 8-day unilateral. So you have to check one of those. What I love about how it's spelled out, and I feel like this changed relatively recently, it used to be a little bit more open-ended. And now, like if I'm the buyer's agent that wants to extend because the buyer's having whatever. We had one recently that the buyer is in critical condition in the hospital. It's not a valid reason to extend the contract, unfortunately. So you got to get mutual, or you're not. It's not going to happen. And we talked. Did we talk about this form in our? Well, I don't think we did. We talked about other things. Anyway, so great form, very straightforward. One of the versions of notice that's important. Notice to withdraw offer. I think this is an important one. Don't forget that you can withdraw an offer and make it no longer valid. It doesn't have to just expire. Very important if you are one of those rare agents that doesn't put deadlines on offers, which I think is a bad idea. But anyway, and then that's it. That's just there's a few other notices and things, but generally speaking, these first few are the ones that I wanted to really go over, in particular, the reminder of important dates. So if that was short and simple, bonus forms. It's not a long. But next time we'll get into the more of the meat of some of the agency agreements, I think is next up on the list. And we'll go from there. Any questions or comments?
I didn't know we were able to withdraw offers, so I learned that.
That is the thing. We can withdraw an offer.
Mhm.
If you get in a situation where your client decides that, oh wait, I shouldn't be buying this house, um, there you go, you withdraw. Because the problem is, of course, if the deadline hasn't passed, or if there isn't a deadline, the other party can sign that at any time during that time
Mhm.
period, and it becomes a binding contract. Now, hopefully, you have some due diligence, although, a few years ago, there were lots of offers written without any due diligence. And
Mhm.
so you'd be in a world of hurt if that happened. So just something to think about.
Yeah, we've used that
Brett,
for withdrawal form in multiple offer situations
Yep.
before as well, because
Mhm.
sometimes you've made a counter offer and then a better offer comes in,
Mhm.
but
Yep.
you've got to use
Exactly.
it
Right.
carefully because you can often burn a bridge
Yeah.
down to the ground when you
You
Yeah.
send.
can you can
When
definitely
you
piss
send that.
people off by withdrawing your offer
Mhm.
back to them, right? The counter.
Right.
Well, it's similar to any multiple offer situation, right? Like there are agents and people that are just adverse to being involved in a multiple offer because they think they're getting screwed.
Mhm.
And they might be. So, it's just one of the things that you'll have to use that professional experience. It's one of the values that we bring as professionals with experience in the business versus just someone trying to make it work and fill out the forms. So that's a very valid point there, Zach or Ken, whatever you want to call you.
Ken. The another thing, and Seth, this is something to remember because sometimes you'll be in negotiations and your buyer might, there's a time limit, and sometimes your buyer thinks they have all the time in the world to respond. And what they need to understand is that yes, this counteroffer is on the table until X time, but if another offer comes in, the seller could withdraw this, and just because you are dilly-dallying, you've missed an opportunity. So it's not to push your client necessarily to make a rush decision, but they need to know the seller can withdraw
They
that
should be
that
aware,
counteroffer.
right? Like if
Mm-hmm,
if you're in a situation
mm-hmm,
where you've got a hot property, so to speak, as a
mm-hmm,
buyer, yeah, just because they give you 2 days to respond to a counter doesn't mean you should
mm-hmm,
take it, right? Like
mm-hmm,
because
Mhm,
this that form that one
mm-hmm.
can knock you out of the running, and all of a sudden you're
Yep.
now in a multiple offer situation,
Mm-hmm,
and you maybe have to resubmit an offer, or like there's just it's not a good place to be as a buyer.
mm-hmm.
So very, very, very good comment. Um, any other questions before we wrap up for the day, the week?
Hey, there's one other form I just want to highlight that I've used once in a
Ooh,
while. It's
okay.
broker's authorization to hire vendor.
Ooh,
That's one I like. And it
okay.
just kind of, you're letting the buyer or seller know, listen, this is my person, but I kind of don't want to be held liable if you're not happy with the work or yeah, something like that. Like you're welcome to hire anybody and you're not holding me liable based off of my suggestion or recommendation.
Okay. Well, everyone will need to go and take a look at that. I'll have to see about including that in the next round of contract classes because
Mm-hmm.
that's a good one. I don't think I've ever seen that one. I mean, that's the fun thing about GAR forms. There are GAR forms for everything. Like if you think of something that's you think's happening, go into the GAR forms and search for, a relevant word like estimate or notice, or there's a bazillion notices. There's so many notices. There, all those things. Vendor, search for vendor, and there you go. I bet you find that one. And so, there are Gore forms for lots and lots of things. This is just a small sampling of those. So thank you for sharing that, Adam. I think that's one that we will all go out and look at now and see what that says.
Yeah, Brett, you might want to add isn't there something we went over on the first round like a year ago, like the unilateral extension of due diligence? You remember that?
So there's the unilateral extension of inspection period,
Okay, I
which
was
is,
close.
I looked at that again when I was putting this one together, and I think that one confuses people more than anything, because
Exactly.
it's not what you think it is, probably. But it's one you can look at. There's a unilateral extension to inspection period. Um, that's a very specific use case, as many of the forms are. Um, there's one of my other ones that I think is interesting is especially in a multiple offer situation, don't do due diligence, do right to request repairs. Those of you that have been in business for a while, you remember a contract that didn't have due diligence in it and only had the right to request repairs. And lo and behold, that limits your ability, your reasons for being able to cancel the contract and terminate. Now, it does bring up other issues because, of course, part of the reason we went to due diligence instead of right to request repairs was the argument of, well, that's not a defect, or that's a defect, or, I mean, you know, oh, there's a split cover plate on the light switch in the hall. I'm canceling the contract. Really? Like, come on. Like, that's not legitimate. So that's why that went away, which I am in full support of. But again, when you're looking for ways to manage a multiple offer situation and you still want to protect your client a little bit, that right to request repairs is not a horrible option. Robin?
Yeah, but wasn't there something in that form that initially it was favorable, and then listing agents and sellers were like, well, wait a minute, because in that it also says if the inspector says that a roofer should look at something or this person should look at something, they have to give you those extra days
I
to
think it
come in
is,
and
I
look
think
at
it
it.
is
And
very
so it
favorable to the buy
automatically,
side. Yes.
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 So I think for a minute they were very, very
But again, it's
favorable.
not as
But then,
favorable as due diligence, right? Like, it's still a step down from that.
yeah.
But it's, yes, it is probably, it leans heavy towards the buyer.
Mhm.
And that's the piece you have to remember, right? We talked about that in the first session. This is a balance of risk project. This is what risk is the seller willing to take? What risk is the buyer willing to take? Um, and what are they willing to pay or give up in exchange for risk, right? Because that's the balance. It's really due diligence, right? In due diligence, like, okay, most of the time sellers are not getting anything in order to give due diligence. But if it's a hot property that has 30 offers on it and half of them include option money, well, now that option money is the payment for the risk of being off market for X number of days and you being able to just walk away for no reason, right? So it's all about that balance of risk. And that's the piece that every single form, every single thing you do back and forth. Back to Ken's point about sending the notice to withdraw the offer. If you're the seller and you get a better offer while the buyer hasn't accepted your counter, yes, you can withdraw that. But it's not always the best choice, right? It's just you have to look at what the risk is and what the potential outcomes might be, and then let the client decide on whether they want to take that risk or not. Um, currently we talked about recently in some of our other classes the risk of not making the contract you have work and make it to closing, right? Like, that's a piece that is important for people to understand. The sellers are, in general, it feels like, leaning more towards giving a little bit more in the negotiation period than they might have been in the past because they don't want to risk having to go back on the market and potentially not sell. We had a long conversation. One of the agents talked about property that was, went under contract and then sat on the market for 5 or 6 months because it didn't sell and because they didn't make that first offer work out. So things to think about. All right. Thank you all very much.
Hey, Brett,
Yeah.
I'm sorry. I have a non-contracts related question about something that's come up in the industry this week that I'm
Okay.
trying to wrap my head around because I don't know if I 100% understand. So I think we've all been getting these emails talking about this clear cooperation settlement, I think it's
So
called.
I am going to defer that to a Word on the Street Wednesday, and we're going to go
Ah,
deep into that
okay.
because that is something we absolutely need to talk about
Okay.
because it's confusing as all get out.
Yeah, I don't understand.
And my
Okay.
recommendation to you is keep doing what you're doing right now.
Yeah,
And then let's talk about the details of that and how that's going to play out.
got it.
And we'll do that on Word on the Street Wednesday,
Street.
probably next week. So we'll get that together. But yes, good point. Excellent point.
Great.
All right. No more questions. Adam, mute yourself. But thanks again, you guys, for coming. I appreciate the participation. I appreciate your interest in making sure that you're writing good contracts. And we will go from there and continue on.
Thanks.
Talk to you later.